All right, now that we've looked at what it is that Title VII is, where it came from, let's talk about how it works in real life. And we know that Title VII permits an employee to sue in court for illegal discrimination. Now, there are two different theories on which an employee can base his claim of illegal discrimination. And these two theories are going to be relevant when we get to the discrimination part of the class. But it's important for you to know them right now because these theories can affect the hiring of individuals. Now, the first theory is called disparate treatment. And disparate treatment involves a policy or an action that is discriminatory on its face. If I have two similarly situated individuals and I treat them differently based on their membership in a protected class, then that is disparate treatment. So say I have a male employee named John and a female employee named Maria, and they both show up late to work one day. And I fire John, but I'm afraid of a discrimination suit, so I retain Maria. Well, what's happened? I have made a decision to fire one employee and to keep the other employee based on sex. So what that means is that John would have a right to bring a claim because he was treated differently on the basis of membership in a protected class. Disparate impact involves policies that are neutral on their face, but which have a negative impact on a protected class. So we talked about employment at will, and you can fire people for almost any reason you want as long as it's not an illegal reason. Well, if I come to work one day and I say, look, I'm going to fire everyone that has brown hair. I don't trust people with brown hair. There's going to be, a lot of people go. And what's going to happen is that people of a certain race or a certain national origin are going to be disproportionately discriminated against. Meaning I am going to wind up firing more Mexican Americans and more blacks and more Chinese Americans if I have a rule against brown hair. So that's a neutral rule. The rule is it doesn't say anything about an illegal class, but it has a negative impact on a protected class. We'll talk a lot more about these in a second. This is just to give you an idea of what they are. Now, proving a claim under Title VII is unique. Ordinarily, proving any claim, you have a breach of contract claim, you have a negligence claim, you have a fraud claim. If you are a plaintiff, if you are the one making the complaint, the one who's bringing the lawsuit, then you are required to prove your case. And you have what's called the burden of proof. The plaintiff has the burden of proof. And in those cases, the plaintiff bears the burden of proof from the filing of the lawsuit all the way through the jury trial. The plaintiff has to prove his case. Theoretically, a defendant, someone who has been sued, doesn't have to appear before the court. Or if they do appear, they don't have to say anything. Even if he winds up going to trial, they don't have to call any witnesses. They don't have to present their case. Ordinarily, a defendant, the party sued, never has to prove that they didn't do it. Instead, the burden of proof always lies with the plaintiff. With discrimination cases, however, that paradigm is altered. Because of the disparity in power between the employer and the employee, the fear was that employers could bury any employee discrimination claim by throwing a lot of money at a lot of lawyers and preventing that party from ever getting to court, preventing the employee plaintiff from ever getting into court. The idea was behind this burden shifting process is we are going to shift the burden of proof back and forth. So we're going to start with a notion of the burden of proof resting with the plaintiff. However, that plaintiff only has to make a very minimal case of discrimination. We call that the prima facie case. Once the plaintiff has made that prima facie case, the burden of proof is going to shift to the defendant to establish that it did not discriminate. We're going to place a burden on the defendant to prove that it did not do what the plaintiff has accused it of doing. That's very unusual in the rest of the law, and it's somewhat unique to the discrimination context. We'll talk more about how it works. Let's start with disparate treatment. Disparate treatment is used for cases of discrimination against an individual rather than a group. And the way a disparate treatment case is brought is the employee must first prove what's called the prima facie case. Prima facie is a Latin expression used in the law. It simply means on its face. It's a very low burden. It's a low hurdle to get over. What happens is when you prove the prima facie case, that's going to lead to a presumption of unlawful discrimination. At that point, the law presumes that the defendant actually did the discrimination. And as I said, the burden will then shift to the defendant to rebut this presumption, to overcome this presumption. Now, there are 4 elements to the prima facie case, and these you just have to memorize. It's going to be something we're going to see a lot when we get into the discrimination portion of the class. First of all, you have to prove membership in a protected class. You have to prove that you belong to a protected class. You're a man or you're a woman. You're a Czech American, you're a Mexican American. You have to show that you are a member of the protected class. Again, usually pretty easy to prove. You have to show that you applied for the job, you were qualified for the job. And when we say qualification, and for terms of the prima facie case, that's a very low standard. What that means is not that you're the best qualified for the job, but instead you meet the minimum requirements of the job. So say you have a job and it requires a bachelor's degree. According to the law, anyone who has a bachelor's degree, no matter where it's from, how long ago it was granted, is qualified to apply for that job. So qualification, don't get confused with the idea that they were the best qualified. It simply shows they met the minimum requirements for the job. Third, we have to show the plaintiff was rejected for the position or suffered some sort of adverse employment decision. This will apply to more than just the hiring process, as we'll see. It could be not being hired, fired, loss of opportunities, loss of pay, any number of things. But for the hiring process aspect, plaintiff was rejected for the position. And finally, an employee outside of the protected class was selected for the position, or the employer continued to look for candidates. So this is a very low standard to get over. If I have a man and a woman applying for the job, they're both qualified for the job, I choose the woman instead of the man now has the ability to prove a prima facie claim. It must have been discrimination. You chose a woman. It doesn't mean that the plaintiff wins. The plaintiff doesn't automatically win. All it means is that the burden is going to shift now to the defendant to say, no, I chose her because she had more experience. I chose her because she had a better attitude. I chose her because she had more education. In those cases, then, I can overcome that presumption of illegal discrimination. I can rebut the prima facie case. We rebut the prima facie case by proving what's called a legitimate non-discriminatory reason. We often abbreviate that LNDR. And this is the best response whenever someone makes a discrimination claim, that you did what you did for a legitimate non-discriminatory reason. That's the defense that an employer will use 99% of the time. The reason why human resources people are in such demand, and the reason why we always keep these employee folders, files, is to establish the legitimate reasons, the non-discriminatory reasons for the actions that we take as employers. So the employer can rebut a prima facie case by showing a legitimate non-discriminatory reason. That's going to put the burden back onto the plaintiff. The plaintiff can then establish, the plaintiff has the right to prove the LNDR is not actually legitimate, that instead it's pretextual, it's a pretext, and that when we say we are using this rule for this purpose, that's not true. That this is simply a means of hiding the unlawful discrimination. So the plaintiff, once I have rebutted the presumption with a legitimate non-discriminatory reason, the plaintiff employee can then attempt to prove that that's a pretext. How do they prove it? Well, they show that I didn't act that way before to other similarly situated individuals. Or there are emails or conversations that I have that establish that I acted not because of the reason that I said that I acted, but because of an illegal reason. So that's how we prove pretext. Now there's another defense that an employer can use. And you need to be careful. This defense is, it sounds like it's going to be very useful, but in fact, it's going to be pretty rare. And it's called the bona fide occupational qualification, abbreviated BFOQ. And BFOQ is the defense that, yes, I discriminated, and yes, it would have been illegal, but I had to do so. It was necessary for me to do so. Now, the first thing you need to know about BFOQ is that it's never available for race or color. Race or color will never be a bona fide occupational qualification, meaning I cannot discriminate on the basis of race or color because the law says I can't. I can never have a job that says I must choose someone black for the job, or I must choose someone white for the job. BFOQ is only available for sex, national origin, and religion. And it is available, as we'll see when we get into discrimination, in very limited ways. Nevertheless, what BFOQ is essentially it's legalized illegal discrimination, a bona fide occupational qualification. If I can establish that I must hire this person for this reason, then I can do so. When we get to religion, we'll see that it has a very broad BFOQ. So if you are if you're a Southern Baptist, but yet you've always studied Hebrew and you have practiced your singing lessons, you know the Torah backwards and forwards, and you apply for a job at a synagogue as a cantor, the person who sings the part of the ceremony, the synagogue can discriminate against you on the basis of BFOQ, that we must hire someone Jewish for that position. It's a bona fide occupational qualification. The employer has to show that this preference goes to what we call the essence of the business, meaning it must not simply be something that you can do, you'll make more money if you discriminate. Instead, it must go to the very essence of the business. And a great case to discuss that is this Wilson versus Southwest Airlines. This is not that long ago case. This is in 1981. Not recent, but you weren't alive, but your parents were alive. And if you know anything about airlines, you know that airlines traditionally hired only female flight attendants. And we'll see a number of flight attendant cases in here when we talk about discrimination, because that was a case where clearly it was disparate treatment. If you were a male, you could not even apply for a job as a flight attendant. Southwest Airlines only hired female flight attendants, like every airline did. And so Mr. Wilson wants a job, and so he applies for the job and says, look, I'm a man, I'm qualified for the job, I want to do the job, but they won't consider me. They will only hire a woman for the job.